All right, we'll now hear argument on 22-944, William Littles versus State of Florida. And you can let me know if you want 5 minutes of rebuttal time or something else.
Let's say 5.
All right, we will.
May it please the court, my name is Robert Berry. I'm the attorney for Mr. Littles. I wanted to start with language from Hine versus North Carolina, where the Chief Justice wrote for the court. The Fourth Amendment tolerates only reasonable mistakes, and those mistakes, whether a fact or law, must be objectively reasonable. And added, we do not examine the subjective understanding of the particular officer involved. And I think that last sentence is the key to this case. I address in my brief every aspect of the trial court's opinion, but I think this case ends very quickly at the objective reasonableness of the stop. And therefore, the rest of it's a fun academic law school exercise, but it really doesn't, we never reach those issues. The stop officer, and I depicted him in the photographs that I attached or included in my brief, show at the moment of truth a police car dashboard cam looking directly at my client's car, which is directly in front of him, which is directly under a green through light at a 5-lane intersection. The officer, let me actually go to the trial court's factual determination. The trial court factually determined that he did not commit a traffic violation, not the ignoring the turn signal violation, not the moving from one lane to another without indicating intention to turn, and not the failure to observe a red light.
Counsel, if I could just ask a question clarifying the facts. It's typically a 5-lane intersection, but wasn't there one, the far right lane closed? Or No. I thought there was 2 red lights and then 2 green lights.
No, and it's exhibit.
So to clarify then the far right lane is the right turn lane.
I believe it's a through or turn lane, but the video is dispositive of that not because of the stop officer's video, but I think it's C, which is the assisting officer has his dash cam light on, and that's where I actually draw some of these photographs from farther back from the intersection.
Right. I guess let me just make clear. It appears to me, at least, that the evidence in the case clearly establishes that there were 2 left-hand turn lanes. The officer was not in either of those. The suspect, Littles, was in front of him in the going forward lane, and they all lined up with the green go-through light. I mean, in other words, that lane, and there's, as I understand, there's really no dispute that's the facts of the intersection and what occurred.
I hope we all agree on that.
Okay.
I recall the right of the 5-lane, the rightmost of the 5 lanes as being an optional. In part, and here's part of the reason I think that. If you look at, and again, I think it's C, or you can actually look at it as Exhibit B. What happens is once you get through that intersection, and my client did this, he changed lanes from the lane he was in and moves to slightly to the right because the 3 of the what I believe are 3 through lanes becomes very quickly 2 lanes after you get through the intersection.
His lane had to merge into the center.
Right. And I think it's a 2-lane, and then he starts to make his turn into the Wawa, indicating both times his intention to move to the right and in.
Counsel, is there anything in the record that indicates what the officer's intention was? The officer was going to the Wawa. He wanted to have some coffee.
He did.
So he was on his way to the Wawa, and you can do 2 things. You can either turn left there at that light and turn right into the Wawa,
Correct.
or you can go straight, and it goes to the back of the Wawa, and then you can turn in from there, which I believe.
And in fact, the assisting officer did the first of the ones you mentioned. He just went to the turn signal and took a.
Right. So it seemed to me it would be odd for the officer, if he's going to the Wawa, if that was his original intent, that he would do anything other than turn left. But instead he would just follow in the car in front of him.
I don't want to try to read your mind as far as the question. I don't think anybody is arguing this has ever alleged this was a pretextual stop for some other reason. I don't. You are correct, and that's how Deputy Giusino, I think, indicated the normal way would be simply to take the turn signal. But he parks behind, and I guess if you take, let me think this through.
Well, he
If you-
testified he knew the area well, he'd been on patrol there before. He goes to the Wawa for coffee. I don't know if the record reflects if that's just the first time he was going to the Wawa, or whether this was, he knows that intersection well because he goes to the Wawa all the time. I don't know. Could you tell me?
He says he's familiar with the intersection, and without getting, I don't think this has any effect on objective reasonableness, but if he is of the mind that he was in one of the two left-hand turn lanes, then he was doing what he normally would have done, and what the other officer did in going to the Wawa is take the intersection turn. He believes, his testimony was that he was behind my client, believed my client was in the turn lane, so from his perspective, which is, as Chief Justice Roberts says, is not relevant to this inquiry, feels as if my client is in the turn lane and is ignoring the turn light and then is running the red light, then he is in the lane he believes he should be in, he being Giusino, the stop officer, to make the left-hand turn to go to Wawa the way that he indicates he thought was normal for him.
If the record evidence in this case showed that the light was, let's say the infraction was allegedly running a red light, but the camera video shows that it was actually green or amber, but the officer said, no, he clearly ran the red light. But the video evidence shows, well, no, he didn't run the red light. The subjective view doesn't matter. Would you then argue, I guess you'd argue that the objectively reasonable officer couldn't conclude that there was a violation because the camera clearly showed that it was not a red light.
I'm sorry to cut you off.
I'm trying to come up with an example.
You can come up with a myriad of examples. That would be another example. I think in my brief, the state cited Willoughby and window tint cases, and if we had a daytime stop, for example, and for alleged violation of window tinting, and you could look at the vehicle and see through the body cam, there's no tinting. This is a 1967 vehicle before they ever conceived of window tinting, and there's none. Then while we can agree that window tinting, what degree it's tinted, et cetera, whether it violates a statute, is a valid reason for stop. If there's no window tinting at all, then it's subjectively unreasonable for an officer to say, I'm stopping him because of window tinting.
Which lane somebody's in is not a judgment call, at least not in this case. It wasn't like he was straddling a lane, was it?
No. He was, I was thinking last night of if I had a second grader write down the numbers 1, 2, 3, 4, 5 and said, what's the middle number of that series of numbers? And the child said 2, or an adult police officer said 2, they're objectively unreasonable. There's really nothing, as much as I try to complicate this case, with all these other arguments, even the trial judge admitted, we're only getting to those arguments because I found the stop was objectively reasonable, and it's not.
Where was the construction? It looked like the construction was on the other side where the merge was. I mean, I understand the officer said it was a confusing intersection and so forth, or at least that was the argument being made. I'm trying to figure out where the actual construction was and why it might have caused confusion, because it didn't look like the construction was of the actual turn lanes and
Right.
or the lights.
The approach to that lane, or I'm sorry, to that intersection from the direction of my client and the stop officer and the follow-up officer, the only thing I see that indicates any evidence of construction is to the left of all of these 5 lanes are some of those orange and red barrels.
They're kind of like
In
in
the
the median
median.
area, or if that is the median, that's where you see it before
Right.
you reach the intersecting street.
Right, there's a couple of those. That's the only evidence of construction that I can see. Like I said, I think I've overcomplicated this in my head, and it's really not that hard. If that's objectively reasonable, that stop in that scenario, then everything's objectively reasonable. I would ask, and I had this recollection, is it Judge Makar? Am I pronouncing your name correctly?
Makar, yes.
Makar. I recall an opinion, and I can't remember what it was about, but you included pictures of a license tag in a First District case, and I think this is a very narrow decision I'm looking for, which is this stop on these facts is not objectively reasonable. Here's a picture of why. Reversed. I think a contrary finding is dangerously broad because it really does say that everything's objectively reasonable. If someone, and here's where I think the trial court made her error, is she included the officer's insistence upon his error as being probative of, included it in that mix, and the Chief Justice says, you know, we don't do that. You look at it objectively, and you all are the objectively reasonable panel here, and you make that decision.
Well, I guess we'd have to do an analysis here saying what would an objectively reasonable officer do or understand at that time and place. And I guess you would argue that an objectively reasonable officer would know that intersection, that's his territory. He should know the light configuration. He should know those would be sort of basic assumptions we would hope every officer has about his or her zone in which they're
My argument is a little broader than that. If this was the first time that officer had ever gone to that intersection, and he's looking at, he's in the middle of 5 lanes, there's 2 to his left, 2 to his right, and there's a stoplight directly above my client's vehicle in the through lane. If it was the first time or the millionth time, it is not objectively reasonable to say, because we all drive around and we go to places we haven't been before, but we managed to figure out somehow where the turn lanes are and where the through lanes are. And so I don't think it turns on his knowledge of the layout, because at that point in time it was so clear. And the only thing I would add is it was kind of interesting to a degree that the state at the hearing focused on construction and said it, you know, the changes made it simple, but so they're making that argument on one hand. On the other hand, they're arguing that my client's self-made videos of that intersection, because of the difference in time, some was not probative. So they were arguing, you know, it's construction, and therefore that's a real important part of the analysis. But on the other hand, when confronted with the fact that it really didn't change, the state was objecting because all of a sudden it didn't become relevant when it didn't help advance their argument. If there's any other questions, I'm happy to answer them, but I've...
One last question. In addition to the lights being in front of the lanes, you also had markers on the lanes themselves. I think the 2 left had, you know, go to the left. And
Yes, they both had arrows.
And on the pavement itself, was there markers to go straight ahead?
Yes, I'm sorry. You're asking if there's pavement indications. Yes. If you want me to find it in my brief.
Furthest to the left had on the pavement left turn arrows in the lanes.
Yeah, if you look.
So you could check by both the markers in the pavement and the lights.
Yeah, the answer is yes. I'm trying to find the spot.
That's okay. That's okay.
It shows up better on video. My exhibit on page 6 of my brief, you can see it a little bit. It shows up more clearly. It shows up more clearly in the video.
The car's on top of, maybe on top of the arrow, but
I'm sorry, I didn't hear the first.
I think on one of the exhibits in your brief, you can't see the straight ahead because the car, your client's car is on top of it, but
Right.
the video shows otherwise. Video shows it.
Yes, I think that's the assisting officer's video that you can actually see these things much more clearly.
All right, thank you.
All right, thanks a lot. I guess I have, almost 5 minutes left.
May it please the court, my name is Chris Davenport, and I represent the state of Florida. I think that the key thing here is you give great deference to the judgment of the law enforcement officer at the scene while still requiring objective reasonableness. This guy
The level of
patrolled.
deference we should give reduced somewhat because of the existence of the videos?
No, because I think the videos are confusing too. The video that shows clearly that he didn't commit these traffic offenses is the video he prepared during the day, where he's parked at that light and shows you the lane next to him. It's pretty obvious during the day. When you look at the nighttime videos, I would submit it's not super clear, especially when you look at number C in the record, which was the second officer who kind of ran that left turn lane light.
Going back to,
It looked like he was in the same lane as the defendant was in when he went straight, and then all of a sudden he's turning. When you look at that video, that was my impression of the
but
video.
going back to Judge Makar's question, if the officer gave a ticket for running red light, and there's a video, and it shows there's a green light, and the car goes, and the judge says, well, I'm going to believe the officer, even though there's a video that says to the contrary, are we required to give the same amount of deference to the trial judge in that scenario when there's a video which shows, which we can view the video as well as the trial judge?
Well, let me answer that, and there's two parts to that. We can view the video as well as the trial judge, but the trial judge had the benefit of the officer narrating what he believed was happening as they watched the video. He did that twice. We don't have that.
But the judge didn't believe the officer in that respect.
The judge found it was objectively reasonable what the officer decided.
No, there didn't have to get to that because the trial judge understood it to be a mistake.
Right, an objectively reasonable mistake.
Right, but it's two steps. I mean, the first part is the trial judge concluded, no, officer, you're wrong. Even though he testified, I'm absolutely right, I'm absolutely certain. The evidence showed he was wrong.
It showed he was wrong, yes.
Was wrong.
But it showed he was wrong, but objectively reasonable because you're looking at how he was viewing it. Even at the hearing, he still felt he was right. And you're looking at why he felt that way, how he was explaining what was out
Does
there.
stubbornness translate into objectionably reasonable? I mean, he was very stubborn, steadfast, whatever word you want to use, and I mean no disrespect to him, because he's obviously a fine officer, but you look at Exhibit A, which is the video, I believe, from his dash cam, and you see Mr. Littles cross the intersecting street, get into the merge lane that then requires him to move to the right. I really don't see the uncertainty here, other than he was convinced, the stop officer was convinced he was in the wrong lane, but
Well, you see that from his video, kind of starts in the middle, his video. You don't see them sitting at the red light. So we don't know if he's moving around. We don't know if that was after he had shifted over, according to the officer. We don't know what had happened before that, because it kind of starts in the
Exhibit
middle.
A?
Pardon me?
You talking about Exhibit A?
Exhibit A, yeah.
You
I mean,
see-
they're just kind of at that light and it's green, versus
See
the
Mr.
officer
Littles go
said
across
he went straight across, yeah.
and gets into the merge lane,
And then
which
merges.
then has to merge
yes,
to the right.
I think that's very clear. But we don't know what happened before that. We don't know if he had shifted over a little bit, because we didn't see the full thing where the lights were changing as they were sitting there.
The officer didn't claim he moved from a left turn lane to the right lane.
Yes, he does. The officer said that what he believed they were in the left lane, and the reason he gave him a ticket is because he moved over and went on that green light.
I'm making a signal.
So, yeah, when the signal turned. That's why he gave him the ticket, is he perceived him changing lanes. Now, in the light of day, that was probably incorrect. Well, trial judge found it was incorrect. The question is, was objectively
Everybody
reasonable?
says it's incorrect other than him, other than the officer.
Well, it's two
Everybody
people.
who's asked, who expresses their view on it, says he was wrong.
He was wrong. He shouldn't have gotten a ticket. That's not the question, because he had to be unreasonably wrong.
But it's not a judgment call what lane you're in, is it? I mean, window tint, how fast somebody's going, I mean, are you driving, keeping within the lane?
That's why I cited cases that weren't just window tint. Let me go back to before I get off track here, to the red light scenario, where the officer says he ran a red light. We have video that shows the light was green. Really depends on, was the light green and then 10 seconds later it turned red, or was it green green, becoming yellow, quick yellow, and then it turned red. I think those are very different scenarios as far as how it was objectively reasonable. I also think you have to consider, where was the officer when he said he ran the red light? Was he parallel to him or perpendicular to him? Was he following him? I think the fact that the officer testified, I was turning left to go to Wawa in my regular patrol area where these intersections are full of construction, even to the date of the hearing, 18 months later. It's one of those intersections that's never finished. It's constantly changing. I was turning left to the Wawa. The defendant was right in front of me. It surprised the officer when the defendant went straight because the officer thought he was in a turn lane. He intended to turn left. That was his testimony. So, you have to consider all of that. I mean, he was right behind him.
But we don't consider subjective view.
No, but you have to consider all of the circumstances. You consider where he was, all of the circumstances, because you defer to the opinions of the officer. The trained officer at the scene.
I raised the question earlier about, we're sitting here, we're trying to determine what is objectively reasonable.
Right.
And it seems to me that there is no clear statutory guidelines for that. There's case law and so forth. But it seems to be a reasonably objective police officer ought to, A, know the intersections, and this is a significant intersection. It isn't like a minor intersection.
Yes.
Right. Should know the configurations of those, should know basically the format of the turn lanes and the stoplights and so forth, the traffic control. That's kind of sort of basic knowledge that any objectively reasonable officer should have, correct?
Yes, but you have to consider all of the circumstances. It's 3:30 in the morning, it's dark, and that's a construction intersection where it's changing every day.
Explain to me how the construction affected this basic issue.
Because it's a lot more confusing when you have to figure out where a lane is, if there's barrels all over and the median is gravel.
But there's no evidence of barrels in the roadway. There's just some
But the
barrels.
barrels were in the median.
Yeah. So how does that change the lane configuration?
I think it makes everything more confusing. The judge found it
If
confusing.
the barrels had been in the left turn lanes, that might have made it confusing.
But they were right next to the left turn lanes.
Yes.
So, it's a construction area. Look, the judge
So
who had
anytime
the
there's
benefit.
so every time there's a construction area, we automatically conclude that there's confusion?
I think if there's heavy construction in an area, it's going to be confusing. That's a factor to consider, yes. But it has to be objectively reasonable. I mean, we're not, the judge who had the benefit of the testimony of the officer narrating what he saw that night, how he perceived the intersection, found that it was objectively reasonable. And I think when you look at it, that's the DVD labeled C, when you watch that, and this was the second officer, so the defendant's not in there, he's traveling down that road and then he turns left. When I saw that, and again, that's my opinion, when I saw that, I was surprised he turned left. I thought he was going to go straight. So that confused me.
Well, that's because the light was green going straight, and he was wanting to get as quickly as he could to the Wawa. So I
he
couldn't tell
turned
whether he had
left.
his lights on or not, or what was going on.
I would imagine he had maybe there was no other cars, I don't know, but
If
you
it-
ran that red light.
Right. If his
Yeah.
lights were on, if his patrol car lights were on,
Then he-
then
right.
he clearly was clearing the intersection, could do what he wanted going through
Right.
there. He wasn't necessarily having to comply with the traffic laws.
But my point is, the path that he took, that confused me. It confused me when all of a sudden he was turning.
Well, I would
'Cause it looked to me like he
agree
was
with you
going
that
straight.
what he did was potentially confusing.
But I'm telling you
because, because he clearly, under ordinary circumstances, would be violating the traffic laws.
Well, yeah, but that's not the confusing part. It's the confusing part was what lane he was turning from.
Did the stop officer ever admit that he was confused and wrong?
He testified that it was a confusing area. He never admitted he was wrong.
So he's-
He remained steadfast, yes.
Let me ask you this on objectively reasonable. You mentioned, we don't know what happened beforehand. So let's say the officer is not paying attention to the car in front. He's looking to the right, left, doing whatever. And then he sees the car go, and he makes the assumption that that car went from the wrong lane. And then the video shows to the contrary. Is the fact that the officer wasn't paying attention or was making an assumption rather than what he visualized, does that turn it into objectively reasonable, or when we determine objectively reasonable, do we assume that it's an officer who is looking ahead?
think you consider where the officer was and what he was doing. So in the red light example, I think it makes a difference if the officer's traveling behind the defendant and the light turned shortly after versus an officer perpendicular at the signal and the light turned 20 seconds later. I think all of those are factors to consider. So I think the fact that this officer intended to turn left and was right behind the defendant, I think that's something you have to consider, whether or not it was objectively reasonable when he gave him a ticket because the guy went in a direction that was unexpected to him.
Right, but
So two wrongs make a right?
Objective reasonableness considers all the
right,
circumstances.
but does objectively reasonable assume an officer paying attention to what's in front of them, or does it include someone who misses the event and makes an assumption?
I think the fact that this officer was paying attention to what the defendant was doing for so long makes this more reasonable.
Well, it
Because
could
he
go-
wasn't just looking around and all of a sudden got surprised. He was paying attention to what was
It
going
seems
on.
like, at that point, it seems like it would cut the other way, which is that he's been following him since that mobile home park he turned out of, and he would have seen clearly what lane the defendant, Mr. Littles, was going into.
I think if this had taken place during the daytime, we would have a tough argument to say that that was reasonable. But it's the middle of the night, it's dark, there's a bunch of lights, and there's a bunch of constructions, and this intersection changes all the time. I think all of those are the factors that make this objectively reasonable. And the whole point of this subjective reasonableness is officers make mistakes. I mean, they're not perfect. This was a mistake. The trial judge found it was. We're not contesting that. It was a mistake. But the question is, the Fourth Amendment doesn't require officers to be perfect. It requires them to act reasonably. And when you consider all of the factors here, and the judge looked at all of these videos, had the benefit of the narration from both of the officers who went through that intersection, so he could really see what they were looking at and how they viewed it. And he found that it was objectively reasonable, or she, I'm sorry.
If the officer thought he was going the wrong way on a one-way street and it really was a two-way street, that's not objectively reasonable, is it?
It depends on the circumstances. If it's the middle of the night and those wrong way signs were pointing at him, that would make a difference versus during the day and it's obvious that there was nothing wrong with it. That's, when you look at these window tint cases, if it's a perfectly clear window, that's a lot different from, well, it's kind of borderline. I would submit this is one of those situations where it's borderline just because of the nature of that intersection and the construction around there.
The trial judge didn't find it borderline.
The trial judge found it borderline in the sense that it was reasonable.
Not borderline in the sense of how dark is the tent or how quick did the light change or anything else. It was
Well,
clearly he was in the straight lane.
I'm using borderline in the context of if the tint is borderline, that's going to be reasonable to pull them over versus when it's a
It's a
crystal clear
judgment call.
window.
Just like eyeballing speed's a judgment call or many other things, but
Right.
what lane you're in when you're fully in the lane.
In the dark, in a construction area with a bunch of signals, and the officer believed himself to be in the turn lane. It's not like he was flying by and saw, driving by at a high speed and saw the defendant and said, oh, that was not a good lane change. He was parked behind him the whole time. I think considering all of those circumstances, and again, the narration by the deputy who was there, who explained why he believed what he believed, I think all of those circumstances support the trial court's finding that this was reasonable. If the court has no other questions, thank you.
The argument you just heard is advocating for rejection of the Chief Justice's language that I cited at the beginning of my discussion with you all in Hine. The argument is that the officer is very stubborn and he really believes that despite all evidence to the
Well, if I can
contrary.
interrupt, we don't put any weight on what this officer subjectively thought. We may put, and the trial court should put weight on the facts that were stated perhaps, but the conclusion that I didn't do anything, I was absolutely certain this was, that we don't put that on the scale, do we? The subjective
State
view,
I had a little
the
trouble getting
subjective
into
view of
the
the
question.
officer? We don't put that on the scale, so to speak.
Correct.
Right.
That's what
It's-
the Chief Justice wrote.
It's the evidence that shows there's barrels on the median, that there's, the council said that this intersection is constantly changing. I guess the configuration of the lanes is there evidence in the record that supports that?
I don't see it. And in fact, again, the state at the trial court level objected to videos of other periods of time, including some made by my client, and I think an investigator for the defense counsel. The court ruled it was irrelevant because it was too far distant in time. Regardless, it's not unclear that night. That intersection is pretty easy to read unless you're invested in misinterpreting what's going on at that intersection.
But you would agree if that intersection was constantly evolving, every week there was some sort of different lane change and different lighting pattern, that would be a very significant factor, right?
Not in an objectively reasonable analysis, because it only matters what it looked like at that particular moment in time. The state argued against it at the trial court level. I understand they're arguing for it now at the appellate court level, but this intersection is quite clear. And the fact that there was construction 6 weeks earlier, that they had barrels blocking turn lanes, or those machines that have the messages with the arrows, turn left in 1 mile because right lane is going to be under construction. None of that's going on here. This is just a drive down a regular road, approaching an intersection that goes, you start on 2 lanes and then it widens out to the 2 turn lanes, at least 2, possibly 3 through lanes, with a option to turn right on the right hand of those 5 lanes. There's just nothing confusing about this. Any other questions?
No, thank you.
I appreciate your time. Thank you.
We will be in recess.